Shortly before Bill 281 was introduced in February, the Guam Solid Waste Authority Board of Directors had passed a resolution requesting the governor pursue legal action against the feds related to the cost of the Ordot Dump closure. Today, Interim Board Chairman Jonathan Denite once again encouraged lawmakers to move this matter forward.
We're in support of 281, and we feel that with the cost to close Ordot, definitely the government of Guam should pursue any venue it can to try and help alleviate the cost of Ordot Dump.
Senator Chris Duane says Bill 281 would authorize the government of Guam to pursue compensation from the federal government for their contribution to the Ordot Dump. The governor's chief policy advisor Arthur Clark says these costs were initially projected at $200 million. However, those costs are nowhere in sight of ending and will definitely be more.
Well, the investigation into the action against the Navy and Department of Defense is a potential claim. Is something that is long overdue.
As we reported and was reiterated today, the Navy built and used the Ordot landfill for 13 years to dispose municipal and military waste before transferring it to the local government. The dump was added to the national priorities list, and the U.S. EPA even issued a Superfund record of decision, noting that the Navy was in fact a potentially responsible party for environmental contamination at Ordot. Clark says environmental experts have indicated this lawsuit is not only viable, but should be pursued.
Because this is the Navy, the Department of Defense, the U.S. federal government, deep pockets, large damages, we've got everybody interested in this.
Deputy Attorney General Pat Mason says the Attorney General's office agrees if there is a viable claim against the feds, it should be pursued, but, quote, this is not a novel idea.
And also, we're not opposed to this bill, the intent of this bill. And we're also not opposed to the fact that in these particular circumstances, we believe a contingency fee would be appropriate.
Mason says the AG's office has also done its preliminary work as well and believes GovGuam should seek a firm with real expertise in the Comprehensive Environmental Response Compensation and Liability Act, or CERCLA, which is commonly known as Superfund. CERCLA was created by Congress in 1980. It provides broad federal authority to respond directly to releases or threatened releases of hazardous substances that may endanger public health or the environment. Mason offered recommendations for changes in the bill.
In this situation, we should be involved, as we always are, to make sure things are on the up and up in the procurement. And we're not going to get involved in policy, and we're not going to start telling experts what to do. And that we also should be the local firm that files the Pro Hoc Vici that admits an expert firm into the courts of Guam.
Clark, however, raised concern about the AG's involvement. He noted that in a filing back in September last year in the Lazon landfill condemnation case, the AGO stated that based on viable evidence does not believe such a claim against the U.S. under the federal CERCLA statute would be successful.
With that premise being their starting premise, again, we have hesitation to let them be in charge of the process going on here. And the reason the governor's office has initiated this and has worked with Senator Duane to get this bill on the floor, quite frankly, it's because it's been 4 years of inaction by the Attorney General's office on this issue.
It's no secret that the governor's office and the AG's office have had very public disagreements and conflicts over environmental issues, particularly with the Ordot Dump. Bill 281, meanwhile, not only authorizes GovGuam to retain professionals, but appropriates $350 to pay for costs and expenses associated with bringing action against the feds. Reporting for Guam's News Network, I'm Ken Quintanilla.
Move on that property, just as Mr. Garrido